You're at trial and the judge tells your attorney, listen, I'm going to dismiss your case because you have a lack of proof. You have not made out a prima facie case to support your claim. Can he go ahead and tell the attorney that he better start negotiating to try and settle this case, otherwise he's going to throw your case out? You want to know what this is about? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and the answer is yes, the judge can say that to the attorney. So now you're in the middle of trial. You've finished putting on all of your witnesses on the plaintiff's case. And now, in just a few moments, your attorney is going to get up, tell the judge, Your Honor, the plaintiff rests. And then, in a few moments later, the defense attorney is going to start putting on his witnesses to defend the case. So now, before your attorney has an opportunity to go ahead and tell the judge that he's finished putting on all of his witnesses and all of his evidence and all of the testimony to support your claim, the judge calls him up during a break and says, Counselor, I want to tell you right now, you have failed to make out a prima facie case, which means you have failed to put on sufficient evidence to let this case go to a jury to have them decide whether you are more likely right than wrong. And the only conclusion he can reach at that instance is, I'm going to have to throw your case out. So if I were you, the judge says, I'd start negotiating with the defense. Now, merely because the judge has told the attorney, your attorney, to go ahead and start negotiating, does that mean the defense is going to want to negotiate? The answer likely is no. They've gone all this way, 2 or 3 years now. Everybody has waited to get to trial. The defense has fought this case tooth and nail. They think they did nothing wrong. They think that nothing that their doctor did caused or contributed to your injuries. And even if it did, they say, hey, wait a second, you're also responsible. And then they also claim, hey, your injuries, they're not really as bad as you claim them to be. So they're fighting you tooth and nail. So what makes you believe that now they're going to be receptive to try and negotiate this case? You know why they might be receptive? If they get the sense or an inkling that the judge is going to throw your case out, now they may be willing to resolve this case at a very, very low amount. That might be a great opportunity for them to get rid of the case without having to pay all their experts and witnesses to come into court and testify and take this case on for another few days or even weeks. So that may be a cost savings that they'll consider. But in all likelihood, they're going to turn around and say, no, we're going all the way to trial. We want a defense verdict. Screw you, plaintiff's attorney. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what can happen in a civil lawsuit involving a medical malpractice matter, a wrongful death matter, and even an accident matter here in New York. You know, I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need answers, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.